Lady,
Yes.
my lords. As my Lord Underhill canvassed at the start of the hearing yesterday, there are two ways that the judge...
Just before you jump straight into it,
conscious of time.
timing, we have had a discussion about it. We would like you both to aim to be half an hour only. If we reserve the right to keep you standing up if there are things that we want to discuss with you further, but that will one way and another give Mr. Adair rather longer. Remains to be seen whether he needs it. I also should say that although said we sit to 4:30, we can only sit to 4:25 because I have a meeting at 4:30. Right.
Thank you, my lord. As my Lord Underhill canvassed at the start of
Justice Underhill.
Sorry, Lord Justice Underhill. Canvassed, sorry, I misread my notes.
Just wanted to put you off your stride.
For the third time, I will try. My Lord canvassed at the start of the hearing yesterday. There are two ways that the judgment in Page can be read. One is that it establishes an evidential rule that where an employer asserts that the reason for their treatment is the objectionable manifestation of the belief rather than the manifestation itself, then it's the objectionable manifestation that's the reason why, unless the circumstances are not such as to justify the act complained of. An alternative way of reading it is that it establishes a legal rule that where the circumstances do not justify the employer's actions, then the objectionable element cannot be separated and the employer is held to have acted because of the manifestation of belief. I want to address each of those in turn, and then I will briefly address what I understand to be the appellant's objections to the guidance of the EAT, and I hope if I have time to complete my submissions, identifying some very practical issues that I would invite the court to keep in mind when considering their judgment. Firstly, Page as an evidential rule. My submissions on this point can be taken very shortly. If it's the judgment of this court that Page established an evidential rule, then in my submission the guidance set out by Mrs. Justice Eadie in Higgs, paragraphs 93 and 94, should be endorsed by this court. The baby should not be thrown out with the bathwater. As Mr. Justice Chowdhury recognised in the case of Holbrook, the judgment in Higgs was an application of established principles set out in authorities such as Page, amongst others. The reference for that is volume 8, page 505, paragraph 97. The distinction that's drawn in Page between the manifestation of a belief and the objectionable manifestation of a belief is not an easy one to draw. It's even harder to draw when one factors in subconscious discrimination. It's not as simple as saying that the employer says the reason for the treatment was the objectionable manifestation and that that's the answer. Rather, the reason why question that's being asked is much more nuanced than that, because it includes the situation where the tribunal finds that the decision maker was consciously or unconsciously influenced by the relevant protected characteristic. Where subconscious influence is in play, then despite the decision maker not being aware of that being their reason for acting, it is inferred to the decision maker. In my submission, identifying that dividing line between circumstances that can sensibly be treated as separate and circumstances where they cannot requires an analytically rigorous solution, and one that is practical, workable and comprehensible to employers and employees across the country. It needs to be transparently clear how that line is going to be drawn. And in my submission, the EAT in their guidance provides that clarity. Paragraph 93 of the guidance, its core bundle, page 86, is an important preface emphasising the fact-specific nature of the issues. Page 86, paragraph 93. It identifies the fact-specific nature of the issues and the values that underpin the rights that are in play. The values of pluralism, tolerance, and broad-mindedness. And it emphasises the need for nuanced decision-making. Paragraph 94 sets out entirely orthodox principles in my submission that will assist a court and employers and employees in the workplace to analyse and weigh whether there is really something here that is objectionable about the nature of the manifestation, or whether in fact it's consciously or unconsciously about the underlying manifestation or belief.
Have I understood correctly that the guidance in paragraph 94 was in fact largely based on your submissions?
It was.
Yeah. Sorry, yes, it was just a factual question. I wasn't about to...
I would just note, before I move on, that the respondent appears to accept that, as an evidential rule, proportionality can assist. That is in paragraph 51 of their skeleton argument, core bundle, page 240. In my submission, this analysis would also avoid the scenario where the employer says, well, we acted as we did because someone else thought it was offensive. That answer can properly be analysed using the EAT structure because it focuses on exactly what it is that's said to be objectionable.
If it's only an evidential rule, why is such prominence given to Bank Mellat in point 4? It will always be necessary to ask, and then the Bank Mellat test is set. Clearly, in a broad sense, as you've said, in applying the evidential rule, you want to see how reasonable the proposed distinction is, because that will help you decide how credible it is that that's actually how the employer was thinking. Isn't 4 a bit over rigid?
In my submission, no. Firstly, because of my second submission, which is that in fact page establishes a legal rule. Which
all right, but on this point, you're...
But in terms of an evidential rule, the reason to include Bank Mellat is to ensure that there is a much more rigorous assessment of whether it truly is the objectionable manifestation rather than the manifestation per se. It's to prevent an employer arm waving and saying, well, in my mind, that was objectionable. As we talked about a number of examples yesterday, where the employer can...
Well, I think you're pushing an open door. No one is, I think, suggesting that it's enough that the employer thinks it was reasonable, thinks that it was objectionable. Oh, sorry, no, I'm confusing myself. Struck the last remark. Yeah, carry on.
So irrespective of whether the court is with me in my second submission, I would invite the court to endorse the guidance given by the EAT as a useful way of providing a rigorous, structured approach to identifying that distinction in page. In my submissions, we have submitted that there should be a minor amendment to the guidance in relation to the extent of the manifestation. Yeah. But that's addressed in my skeleton, and I don't propose to deal with it further. If I can then move on to the situation where page is a legal rule, I want to break this down into 3 points. Firstly, when it matters, whether it's a legal rule or an evidential rule. Secondly, why indirect discrimination is not the answer to these cases. And thirdly, how page, as a legal rule, operates within Section 13 of the Equality Act in the context of Section 3. So firstly, when does it matter? When matters were being discussed yesterday, it was observed that in 99% of cases, using page as an evidential rule will answer the question asked and will enable a coherence between Section 13 and Article 9 and Article 10 rights. And we say that is particularly so if the rigorous approach in Higgs by Mrs. Justice Eadie is applied. But there are cases where Page as a legal rule would be relevant. This arises where an employer says something is objectionable when it plainly isn't, and they persuade the tribunal that it really was their reason, despite it not actually objectively being objectionable. Then there would be no direct discrimination, but there would be a breach of Article 9 and 10. Can I take a rather silly example?
All right, you go first.
I'm sorry.
I was about to put an example to you, but let's hear yours first.
If someone's a committed environmentalist and posts on social media, I'm horrified because so many trees are being chopped down and killed, the employer could say you're dismissed, not because of your environmental beliefs, but because I object to your use of the word killed in relation to the trees. Now, on the respondent's case, if they can persuade the tribunal that that was really the true reason, then on their case there would not be discrimination, because the employer's genuine reason was the use of the word killed, despite the fact that everyone here would say, well, hold on a moment, there's absolutely nothing objectionable about the use of that word. So on that analysis, there could be a finding of no discrimination, but a breach.
But is that so terrible? I agree. It seems incredibly unlikely that he would be believed if he said that. But suppose he is believed. So it's like my silly example yesterday of the grammar pedant. If really that was, of course, slam dunk for unfair dismissal, but why are we in discrimination territory? The environmentalist has not been, or indeed why are we in Article 9 territory? Because nothing has happened to that person because they are an environmentalist.
Because their right to express their belief, which falls under Article 9 and 10, has been constrained, interfered with by their dismissal. So there's no discrimination claim because there is no reason why, but their Article 9 and 10 rights have been interfered with. They've been prevented, they've been affected when they've sought to express their rights, express their beliefs.
Yep.
This was also recognised by the Commission in their original submissions, and I would invite the Court to go back to the Commission's original submissions for this case. Having addressed the cases of Chondle and Wastany in paragraph 38 of their submission.
Where do we have
the supplemental bundle?
You mean for this appeal?
For this appeal.
Yes, of course they didn't intervene for those, of course.
No.
Yep, sorry.
So if we pick it up in supplemental bundle, page 177, paragraph 38. They had addressed the cases of Chondle and Wastany, and then in paragraph 38, they identify that the cases are consistent with the principle in Bugnawi and Achbita, and they identify that great care is needed in the distinction that is being drawn.
Okay.
If we then progress to paragraph 43 of the submissions, I just invite the Court to read that.
Yep.
And so the difference between us originally was simply one of sequencing. My submission was that you read section 13 in the light of Articles 9 and 2 straight away. The Commission's position was you deal with section 13 and only if there's no discrimination do you then go on to look at Articles 9 and 10. using Section 3 to do that, and they expressly submitted at that point that there was no barrier to doing that and to read the two compatibly. So I raise that simply to make the point that the Archbishop's Council is not on a frolic of its own. This was the position of the Commission at the outset of this appeal. So in my submission, that's why it matters. It matters for that 1% of cases where you have, or maybe it's more, but in the examples we were discussing yesterday, those cases where the employer persuades the tribunal that the reason why is something that everybody else would say is utterly unobjectionable. My second subpoint is why an indirect discrimination analysis doesn't answer the question. Very straightforwardly, it's because the PCP that is formulated in these cases is not neutral. And that's the fundamental requirement of indirect rather than direct discrimination. We see that in a variety of CJEU case law, like Higgs and Wade. If I can take the court to that, I'm not sure how familiar and how recently the courts have.
At the moment, it doesn't ring any bells at all, but maybe when I see it.
Very well. It's in volume 8. I'm sure I'm pronouncing it wrongly as well, but it's volume 8, and the case starts at page 103.
So I suspect it's IX, not X. But,
yes, IX and Farmor, I suspect, actually, as well. It's a German
yes, right.
case.
Never mind, yep.
This case concerned whether an internal rule relating to dress codes was direct or indirect. And we can see in the, if I can simply take the head note for now, on page 104, held the first point, any internal rule prohibiting workers from wearing any visible sign of political, philosophical or religious beliefs based on a policy of neutrality.
Sorry, where are you reading from?
I was just reading from the held 1 on page 4.
Oh, yes, I see. Yep.
In fact, if I can just invite the court to read held 1 and held 3.
1 and 2.
1 and 3.
1 and 3. Right.
So a rule banning conspicuous large-sized signs was held to be direct discrimination, whereas a rule that applied in a general and undifferentiated way, that would be a matter for indirect discrimination. And in the same way, in my submission, when unequal treatment is based on a criterion that's inextricably linked to the protected ground, then you can't formulate a neutral PCP.
I don't know the case, but does 3 mean that you could have a conspicuous large size sign saying anything else, like I am a conservative or I am a socialist or whatever, but if it was religious or philosophical, then that wasn't allowed?
The court in Farmor was indicating that it included political, philosophical and religious beliefs because they were concerned with both Articles 9 and 10. My point really, my lord, is this, that when one thinks about these kind of manifestation of belief cases, formulating a neutral rule is so difficult as to indicate that it's artificial. And what we're really concerned in these cases with is unequal treatment that's based on a criterion which is inextricably linked to the protected ground. And that means it is direct discrimination. There may be many scenarios where a manifestation of belief can be boiled down to a neutral policy. No headway whatsoever. But when it is about a particular person's posts on social media, then that would be direct. And in my submission, when one considers the PCP that Mr. Jones formulated yesterday, the same point becomes clear. He framed the PCP, and I no criticism of him, it was on the hoof because he was asked to do so. But the PCP he framed was as a policy of the employer that people should not post something offensive on social media. But of course, what is offensive is at the very heart of what is being stopped. That itself is not a neutral criteria. If I can go back to the T-shirt example, if you imagine a policy where you can wear what T-shirts you like, so long as they're not offensive, if I held gender-critical beliefs and I tend to work in a T-shirt that says a man cannot become a woman, that would be offensive to some individuals in the workplace. But in my submission, an employer disciplining for someone for that is not applying a neutral policy because it's directed at the protected characteristic that is in play. It's inherent to that assessment of whether something is offensive, and it becomes deeply artificial to try and formulate a neutral PCP. In addition, as was identified by the court, there are very significant problems of group disadvantage.
Sorry, carry on now.
There are very significant problems of group disadvantage because effectively what would have to be shown was, because I hold strongly held beliefs, that makes it more likely that I'm going to be offensive to others. And that would itself equate to a very significant restriction on people's ability to express their beliefs. I would just note that in fact this is in accordance with the Commission's Code, Volume 1, page 181. It's the sentence just above the pink box. Placing limitations on a person's right to manifest their religion or belief may amount to unlawful discrimination. This would usually amount to indirect discrimination. And so it's clear from the code that, again, the Commission identifies that there may be circumstances, and there are circumstances, where it would be direct discrimination. My final point on this issue of direct and indirect discrimination is simply to turn the court to the case of a mover. It's volume 9 and it's page 20, paragraph 57.
Can you just pause for a moment?
Of course.
Just suppose, I think the answer to this is straightforward, I just want to make sure I've understood it. Suppose the employer does actually have a published policy which might be quite difficult to formulate, but let's leave out religion for the moment. Just say, at a time of political polarization, he says no political, no expressions of political belief in the workforce, in the workplace, because it only causes ill feeling and riles people up. Someone is prevented, therefore, from wearing an I'm a Conservative T-shirt or red rose, whatever it might be. That would be, you say, indirect discrimination.
Yes.
If they have no prior policy, But one day someone comes in wearing a, mixing my examples in countries, Make America Great Again cap, and he dismisses them. That would be direct discrimination for political belief.
Because it's targeted to that individual for what has happened with them. There's not a policy that's applied across the board.
What if he said, and it was believed, it would have been the same if he'd come in wearing a Kamala Harris badge? Then it's not, well, it is targeted in the event that happened,
Yes.
but it is not targeted according to how he would have behaved with a hypothetical comparator. What's the analysis there?
It's still direct discrimination. You're just identifying what the reason why was.
Right. Okay, thank you. You were going to take us to Amuba.
It's simply to identify the problem. Mrs. Justice Eady, in Amuba, paragraph 57 of the judgment, it's page 20 of volume 9. In my submission, pithily identifies the difficulty that arises in these cases. Although not before me on this appeal, the claimant also brought claims of indirect discrimination against both respondents, which the tribunal found to be fatally flawed, as the identification of a provision, criterion or practice in each instance was simply a restatement of the complaints of direct discrimination. And that's the practical outworking of forcing these matters into indirect discrimination.
Sorry, which paragraph?
I'm sorry, paragraph 57 of
Thank
the
you.
I'm sorry, my lady, I'm so conscious of time, I'm
That's
going
all
too
right.
quickly.
Okay, thank you.
And that's the practical outworking of the problem. If it's forced, if these sorts of cases are forced into indirect discrimination claims, you end up with PCPs that are actually restating the direct claim, including the protected characteristic, because you can't identify that neutral PCP that's in play.
So as I understand it here, the PCP is someone expressing the same views, or the proposed PCP was the same views, but without the underlying beliefs, which I think you're highlighting a difficulty with.
Precisely. And even if you try and abstract it even further to say, well, it's offensive views, that idea of what an offensive view
that's
is
it's
more
the qualitative element of
Precisely.
offensive that causes the problem.
Precisely. That takes me to my third point in relation to Page as a legal rule, and that is how it operates within Section 13 in the context of Section 3 of the Human Rights Act. In our submission, it is possible to read down Section 13 so that it accords with Articles 9 and 10 of the Convention, and it is necessary to do so.
Well, hang on, what about the point? Ah, right. What about the point that it isn't necessary to do so?
Well, in my submission, that relates to my point about when Page becomes a legal rule and when you need it to become a legal rule.
Yes, I see.
Because that's when the gap arises, when you have something that the employer says is objectionable, the tribunal accepts, against all the odds and against all the evidential use of the Higgs guidance, they accept that in fact that was the reason why. But nevertheless, somebody's Article 9 and 10 rights are interfered with. Now, it may be that this court decides that that's not the case here and it doesn't need to be addressed. But if I may, I'd like to address how it can and should be addressed. The submission that it's possible to read down Section 13 was a position with which the respondent expressly agreed before the EAT, and as I've already prefaced, this was also the position of the Commission in their original submissions. We see that in paragraph 43 of those submissions. Starting at the beginning then, under this heading, my first proposition is uncontroversial. The Equality Act must be interpreted so as to be in compliance with the Convention. As the court noted in Page, the protections under the Convention and the 2010 Act must be intended to be coextensive. Secondly, in my submission, the protection provided here is either the religion or belief of the individual or the manifestation of that religion or belief, where the manifestation is intrinsically linked to the religion and belief. And this is a point that appears to have been trailed by the respondent, and I want to meet it head on. Can I turn you to the respondent's skeleton, core bundle, page 222. And it's paragraph 5. The argument that the reason why has to be the belief, not even the manifestation of the belief, stretches far beyond the distinction that's being made in Page between a manifestation of belief and an objectionable manifestation of belief. Mr. Jones gave 4 examples of issues relating to the manifestation of belief yesterday. His first was where the manifestation reveals the belief, but it's the belief that is the issue. In none of his other examples did he deal with the scenario where the employer objects to the manifestation of the belief per se. Not because it reveals the belief or because the manifestation is objectionable in some way, but simply because of the manifestation itself. So, for example, where an employer objects to a woman wearing a headscarf simply because it is a headscarf. Mr. Jones, I think, would say what has to be shown is that the objection to the headscarf reveals an objection to the underlying Islamic beliefs. In my submission, that adds a step into the analysis, a requirement to connect the employer's objection to the manifestation to an objection to an underlying belief that simply isn't what the case law requires. Let me make that submission good by reference to 2 cases. If I can turn the court to the European Court of Human Rights judgment in Ewada, I don't even know that the court needs to turn it up, it's such a familiar passage, but it's volume 5, page 385. Paragraph 82.
Yeah.
It's the intimately linked point that is made there. So when at the tribunal...
Is this the passage where... No, it doesn't appear to be. Where it is said that the objection to the manifestation is a proxy for the objection to the belief. I don't think that's here, but is that the same concept? Or is that a different concept?
It's precisely the same concept. It's not the particular passage.
Is that where... don't take me to it. Can you remember where that concept of... I'm feeling it may be something Lady Hale said somewhere.
In Lee and Asher's.
It's Lee and Asher's, thank you. Yep.
I can find the precise reference.
Don't worry.
As soon as I sit down.
No, your time is short, I wouldn't.
This is, I don't think I even need to make the point good with the second case, but I'll flag it so that the court can look at it later. Decker, the Court of Justice in relation to pregnancy, identified that the pregnancy was one and the same as sex. And we say when one considers...
That's a more complicated example, but you get what you need out of Ewada, don't you?
I do. So it's a proxy. The manifestation is a proxy for the belief. So you don't need that extra step that it appears that the respondent is putting in. That takes me then to my third proposition, and that relies on paragraph 67 of Page and the phrase circumstances are such as to justify the act. In our submission, justify should be understood to be the same question as must be answered when addressing Article 9.2 of the Convention. Now, the major criticism of that approach has been that this introduces an objective element to the assessment. In my submission, the Convention and the Equality Act have very different architectures, but I say they can and should be read compatibly. They should be blended in the same way as in X and Y at Lord Justice Mummery. And I would emphasise here that we need to be very careful about what we're talking about when we address the reason why. It is not a test of factual causation, it's a test of legal causation. We see that in Nagarajan with the significant influence test. And once you add in subconscious influence, we've moved a very long way from a pure but for subjective test. Separately, we submit that one must also bear in mind section 23 of the Equality Act. While a comparator may not always be useful, the fundamental exercise that's being undertaken is a comparative one. And when one is determining no material difference between the circumstances, that is an inherently objective assessment. To decide what a material circumstance is or is not is inherently objective, whether that's an actual comparator or a hypothetical comparator, because the tribunal is determining what is or is not a material circumstance. You're not asking what did the decision maker think was a material circumstance. And so on that basis, in my submission, it is not judicial vandalism to say that when you're looking at the reason why, there is an objective element to that assessment. I realise I've gone through that at quite a pace.
No, that's very helpful.
And in those circumstances, it's not judicial vandalism to have a legal rule of proportionality in circumstances where the employer is trying to make that distinction between objectionable manifestation. The scope of the interpretive obligation is very broad, and in my submission, we are very much in the territory of X and Y, paragraph 57.
But these are all in your submissions, and we know.
Can I finish then?
Yeah.
There, in terms of two very brief points. The appellant's objection to the guidance. My Lady Justice Falk identified it seems that the appellant's objection includes a criticism of insufficient emphasis on the foundational nature of the rights. In my submission, that's not a fair criticism. We see it up front and centre in paragraphs 93 and 94 of the guidance. And then I just want to finish by highlighting very briefly some important practical points. It's absolutely right that there are some very difficult legal principles in play here, but it's also important to bear in mind that in this area of law, it's playing out in workplaces to an ever increasing degree. And whatever the judgment of the court, it needs to be something that employers and employees can actually practically use and navigate. Mr. Jones set out 5 different ways of analysing manifestation of belief cases with different T-shirt scenarios. Now, Mr. Jones is a very intelligent man, and he's constructed a very interesting set of distinctions. But I suspect that if a claimant trying to bring their claim before the tribunal tried to understand what her claim was about, comparing to different people wearing different T-shirts, she would be completely and utterly lost. In my submission, what is needed and what the EAT provided was a practical, workable analysis for both the courts and individuals. And what the analysis avoids is a game of trumps. A game of trumps of it's everything to do with the employer's reason, no matter how objectionable or sensible it is, and a game of trumps that says if it's a religion or belief case, That's the end of it. The EAT's guidance provides a central middle ground to navigate very difficult issues. Unless I can assist the courts further.
Not my case. No, thank you very much indeed, Mrs. Fraser-Butt then.
Sorry.
Yes, Ms. Clement.
My Lord, yes. As the Court knows, I appear for the Commission, which is the statutory regulator for ensuring compliance with both the Equality Act and the Human Rights Act. And we've set out at paragraph 6 to 10 of the written submission why the Commission is interested in intervening in this case. And my Lords, my Lady, one of the key reasons is that one of the specific regulatory priorities for the Commission is freedom of expression, including expression founded in beliefs in the workplace. And the Commission is very concerned about this category of case that has come before the Court. These do raise difficult legal issues, and so we are here to assist the Court in the resolution of those issues. But to ensure there's no misunderstanding, the Commission fully endorses the importance of the Article 9 and 10 rights that Mr. O'Dare outlined yesterday. The issue is not whether those rights are protected. The issue is how. My Lord, I also want to be very clear that the Commission does not make submissions on the facts of this case or how the Court should dispose of this appeal, which may raise its own issues. What I do is adopt the written submissions as have been clarified in my supplementary note, and that clarification is important. And in these 45, well, I did say 45 minutes, 30 minutes, I intend to cover two topics if possible. The first is the relationship between the Equality Act and the Human Rights Act, and the second is the role of stereotyping and third-party objections in direct discrimination cases. Now, before I can turn to the first of those, there are three preliminary points that I need to make that are important to understand how the two acts work. The first is the nature of convention rights. It might be thought obvious, but it does seem to be missed in a lot of these submissions. Articles 9 and 10 protect a substantive right. Article 9 protects the belief and the manifestation of the belief. Those are qualified rights, they can be justified. What Article 14 does, Article 14 is about discrimination in the exercise of those rights. So the premise for an Article 14 analysis is that there has been no breach of the underlying article, but there can nevertheless be a breach of Article 14.
Why are we troubled with Article 14?
Well, my Lord,
The discrimination issue here is discrimination under domestic law,
yes,
which is not, the rules are not quite the same as under Article 14.
yes.
And I think at this stage of the hearing to introduce problems with Article 14 is not going to help us.
My Lord, it's not to introduce problems, it's to make the point, and I'll come to it when I deal with what the Free Speech Unions say. And can you limit the scope of a manifestation that is protected by Article 9 to those manifestations where there's not an interference that can be justified under Article 9 too? You can't in my submission, because the Convention protects when you're within the ambit of Article 9. So if you have a belief or you have a manifestation of that belief, you are within the ambit of Article 9, and Article 14 protects discrimination within the ambit of Article 9. So it protects all manifestations of belief that are true manifestations, and in accordance with the WADA, are protected. You can't limit that to say it is only the manifestations that do not breach Article 9, but do not breach Article 9 too. Otherwise, you've got a whole other problem if the Free Speech Union are right. It's a different problem, but it's a very, very difficult one. My Lord, the second preliminary point is what's the nature of the Equality Act. I've set this out in my note. Where does it come from? It is derived from the framework directives. It is derived from almost half a century of EU provisions. Those provisions were themselves designed to comply with EU general principles of human rights law, to comply with the Charter. So it is a surprising starting point if we get to a position where the Equality Act is incompatible with convention rights. But, as your Lordship just put to me, the Equality Act does confer greater protection than the Convention in that one crucial respect. And that one crucial respect is that under Article 14 you can justify direct discrimination. Under the Equality Act, say for age, you cannot ever justify direct discrimination. And I know, my Lord, the Court has made reference to the opinion of the Advocate General Sharpston, in the Bugnawi case.
Yes.
And that is a very useful illustration of how the two regimes are supposed to fit together. And the point that the Advocate General makes there is that there are fundamental differences between the two legal regimes, between that under the Convention and under EU law. She makes the point that under EU law, direct discrimination is stronger. She makes the point that that is a legitimate difference, and the EU law is entitled to do that. And she expressly rejects the suggestion that some form of blending, and maybe this is where the term blending comes from, some form of blending of the two categories is appropriate. She expressly considers that and rejects it. And what she says is that the distinction between these two types of discrimination, two types of legal order, is a fundamental element of EU legislation. Now, I'm not going to turn it up, but if I can give your Lordships, your Ladyship, the note, the reference, Volume 6, tab 96, page 450, and the discussion starts at page 465.
This is the Bugnawi Advocate
Yes.
General. Yeah.
Exactly.
Well, I'm making myself, I reread it last night. Yeah.
I'm grateful, my Lord. So your Lordship knows the point I'm trying to make. The third preliminary point is the nature of the protection afforded to the manifestation of a belief. We know Equality Act, the protected...
No, sorry, I thought that was the third preliminary point.
No, my Lord, that was the
Second. Okay.
first one was the nature of convention rights. Second is the nature of the Equality Act. Third is the nature of the protection afforded to a manifestation of a belief. Equality Act defines the protected characteristic as religion and belief. Awada tells us when an action that is inspired, motivated or influenced by religion or belief constitutes a manifestation. That's paragraph 82 of Awada, volume 5, tab 83, page 355. Then we say what types of manifestation of belief, religion or belief, are protected under the Equality Act or under, as it derives from EU law. And the answer to that comes from both Bugnawi and Achbita in the Court
And
of
which, sorry?
Justice. Bugnawi, which...
Bugnawi and you said another case.
Yes, the second case, Achbita,
Achbita, yes,
A-C-H-B-I-T-A.
right.
It's volume 6, tab 95.
Yes, we haven't been taken to that. But
They're decided together, they decide the same, one after the other, they
I
decide
hadn't
the same
appreciated
thing.
that. Okay.
And what they both say is that the term religion or belief in the directive, from which the Equality Act is drawn, covers both the forum internum, so the fact of having a belief, and the forum externum, so the manifestation of that belief. So the definition, the founding definition in the Equality Act, covers both. What the Court of Justice does not say is that the protected characteristic of religion or belief only covers a limited type of manifestation, the interference with which cannot be justified under Article 9.2. So the Free Speech Union, we say, is wrong to say that the answer to all of this is to read down the definition of a protected characteristic, to say it only includes a manifestation that satisfies a waiver unless they take a form which objectively justifies restricting them under Article 9.2 or 10.2. That is far too narrow a definition. It would both cut down the scope of Article 14 protection, the reasons I started with, and it would be contrary to the Grand Chamber judgments of the Court of Justice in Bugnawi and in Achbita. So, my Lord, that brings me to the issue at the heart of this appeal. We've got the increasing number of manifestation cases that are drawing a distinction between the manifestation or the expression in question and the manner in which it is done. So what is the correct legal framework for that? My learned friend Mr. Jones gave you 4 options yesterday all of which the Commission would adopt. So either you've got a situation where the manifestation reveals the belief, so the belief is the real reason, direct discrimination, not a difficult.
Hang on 1 second. So you say all Mr. Jones's alternatives are in fact not alternatives, that, well, maybe they're all available in particular but different circumstances.
Yes. Yes. So, my lord, you could also have his second option was that the employer objects to the manifestation of a particular belief, but would not object to the manifestation of others. That's a prime direct discrimination case. Treating someone differently because of the manifestation of the belief. The third option is the indirect discrimination analysis.
Sorry, I'm being slow. Perhaps you're being too quick, but I understand why. The first one is the case where you can find on the facts that you were not objecting, you were not motivated by, whatever phrase you like to use, the religious belief or its manifestation, but only the manner of its manifestation. And you say that's a legitimate distinction in some cases,
Yes.
is that right?
That's the difficult category that we're dealing with. That's Mr. Jones's category 4.
Well, it may be difficult factually, but it's not difficult. I'm not quite sure what you're saying about it.
My lord, what I'm saying is I agree with the 3 different ways that these 3 different categories that these can fall into. You've got the manifestation that really reveals the underlying belief. That's an obvious direct discrimination case. You've got the employer objecting to one particular manifestation of a belief when they don't object to another one. Again, that's a direct discrimination case. You then have an indirect discrimination case as a different way of prism through which one views these. But you have an indirect discrimination case when you have a neutral rule, when you have a PCP that is applied to everyone. Now, my learned friend says, oh, she gave some examples from different cases and says these aren't neutral rules. Well, of course, it's going to depend on the facts. One has to look at what is going on here. Why is the employer doing what it's doing? If it's applying a neutral rule to everyone, that is classic indirect discrimination. Can't be direct discrimination. Now, my Lady Justice Falk asked yesterday, how would this work through? How could this be an indirect discrimination case? I haven't got time to deal with it on my feet unless the court wished me to, but I did spend some time overnight drafting up what it would look like. I'm not saying this is the only way it could be done, but it shows the analysis, the indirect discrimination analysis, that we say could well be in play in cases of this nature. So you look at what is the PCP, and there's a number of different options of what they could be, and then it follows through the analysis under Article 19.
Sorry, I got lost. What does all these things?
Sorry.
You were saying it does this, it does that. What does this or what does that?
Well, could I hand it out?
Oh, I see. You've got the
So you can
document
see
for
it,
us.
yes.
Have you shown it to everyone before?
I
Particularly, have you shown it to
haven't
Mr.
yet, I'm just going to hand it.
Well, I really think it would have been better to have shown it to Mr. O'Dare in particular a bit earlier. Why wasn't that done?
My lord, it was done very late this morning. I'm terribly
Oh,
sorry.
I see.
Should have had
All right.
that.
Thank you.
My lord, may I just briefly say something before we go further forward?
If it's going to be useful to us, if it's just going to be a complaint, keep it till later.
With respect, just a complaint hardly does it justice, but I'll wait till later.
My lord, it's an attempt to deal with the question that my lady put to my learned friend Mr. Jones yesterday. It's an attempt to be helpful. If it's not, I'm happy to put it to one side, but it is an attempt to deal more quickly in writing than I would have time to deal with orally.
At the moment, I think we're in a difficult position. This has either got to be worked through carefully and explained bit by bit. At the moment I look at it, I can't see what it's for or what it does. Now, that would become clear if you spent the next 20 minutes, but you haven't got the next
Yes.
20 minutes. Speaking for myself, I'm just going to put this to one side. I don't promise not to look at it later, but I think I can say that if, in my case at least, it plays an important part in our thinking at some later stage, we will make sure we ask Mr. O'Dare's submissions about it, or indeed the other parties' submissions about it. But it may be it isn't actually that important.
My lord,
But I
it's
don't
an
think I'm
attempt
going to
to be
ask you to
helpful
allow you to
if
develop this at the moment.
If it's not helpful, then I'm content to put
Well,
it
I don't know if
to
it's helpful or not, but I think there isn't the time to find out whether it's helpful.
My lord, the point is simply, it's all going to depend on what the actual rule that's being applied is. If it is generally a neutral rule, which it is capable of being in these types of cases, then it is properly an indirect discrimination analysis which must apply. And as the EHRC Code of Practice, as the Commission Code of Practice says, expressly states, most of these cases are likely to be indirect discrimination cases. It doesn't say all, the code doesn't say all, there will be some that aren't, but it depends on what the employer is actually doing, whether it is a distinction, so it's direct discrimination, or whether it's applying a neutral rule, policy, provision of code of conduct, whatever it is. If it's neutral, it's indirect discrimination. If it's not, then it's direct discrimination. And my lord, then in terms of these particular cases where you have the employer doesn't object to the manifestation of the particular belief, but does object to the manner in which it is manifested, they are a little more difficult to analyse, of course they are. The answer to that is either the separability analysis, which the court has heard. There may be a scenario where the employer's reason is based on a stereotype or is based on a third-party complaint which is in itself tainted by discrimination. Those, we say, are straightforward applications of direct discrimination. The court's familiar with those cases, the DIN case law, etc. I'm not going to go to those. Or the complaint is properly analysed as one of indirect discrimination because it is a neutral
So are you saying the separability analysis is never appropriate here? The kinds of cases where it might be applied can be dealt with in other ways.
Well, but look, it depends on what has happened and the reason why. It can, if it's a separability analysis, the direct discrimination claim will fail.
So you've just said that's one alternative,
yes,
as I understand it.
Yes. So
others are the stereotyping approach, or only indirect discrimination.
yes. So if you apply the separability analysis, if the reason why is on the prohibited ground, if the reason why is the belief or the manifestation, that's direct discrimination. If that is not the reason why, you've got the separability, and it's not direct discrimination because it's for a different reason.
Yeah, well, so what are you saying? I'm a bit lost.
I'm saying that it will inevitably be one or the other.
What is one and what is the other?
The other is it's either going to be a direct discrimination case because the real reason is the protected characteristic. If it's a separability case and the real reason is something different, then you look at the indirect discrimination analysis.
Yeah.
Because the tribunal will have found the real reason is something else.
Well,
not
let's take a classic separability case. Somebody expresses a protected belief, but does so accompanied by threats of violence, and they're sacked for the violent way in which they did so. That's, you would have thought, straightforward, not the reason. I don't quite see how an indirect analysis, indirect discrimination, I suppose you would then say, well, if someone had said threats of violence, but not in a religious context, maybe a football context, you would have said, don't do it again.
Yes.
Then you'd have discrimination for that reason.
So your PCP there would be, don't make threats of violence. Your code of conduct would say, you could be sacked if you make threats of violence. And you then look through an Article 9 analysis, because that reflects Section 19, you look at whether that's justified. So the point I'm making, my lord, is that there is no gap, there is no incompatibility in this legislation. Because if you don't get your claim of direct discrimination because the reason why is a permitted reason, You look at it in the alternative
Okay.
through the
Well, this is the
prism
key
of
point. There is no incompatibility gap because all conceivable situations can be dealt with by the existing tools, by the existing analyses of direct or indirect
Yes.
Okay.
So there's no incompatibility. My lord, all of what we say the court cannot do is to shoehorn a justification test into Section 13 when Section 13 of the Act does not have one. Now, what it is said by my learned friend, Mrs. Fraser-Butlin, is, well, Page requires you to do that, or it's a good idea to do that, so let's do it anyway. We say Page does not require this court to do that, and I adopt what Mr. Jones says about Page. Given the time, I'm not going to repeat it. Set out in our written submissions as well. There is nothing in Page which requires, as part of the ratio of the judgment,
Okay, well, you've said that.
about no test. My lord, so then that leads to the question, what doesn't Page decide? And I need to just make one point on that as well. What Page doesn't say is that there is a requirement, as part of the ratio, there's a requirement to consider convention rights first without looking at matters.
Now, we've had that point before,
So, my lord, we have that. So if the court is not bound by Page to introduce that proportionality into Section 13, what is the correct approach? We say the correct approach is that set out in paragraph 11 of my written note that the court has. Go through each of the steps. I'm not going to go through them, but the key one that is absolutely central here is you only get to a Section 3 analysis if the primary legislation is incompatible with convention.
We've got that point as well.
So we say if there are claims that the claimant could have brought under the Equality Act but did not bring, one cannot get to a situation where the Equality Act is incompatible with the Equality Act is incompatible with convention rights. My lord, I cannot find a single instance of a situation where that kind of scenario has amounted to a breach of Section 3. Where you have Section 3 brought into play, it is where the legislation confers no vehicle to vindicate particular convention, whatever convention right it is. So like the case in Mercer, which my Lord Justice Bean will be very familiar with, there was no means in that underlying statutory framework to vindicate a claimant's Article 11 rights.
Yeah.
Here, you can't just look at the claim that was brought, you look at the entire framework of the Act.
Yeah, we've got that point.
So, my Lord, even if the court is against me on that, and somehow the court finds that because the claimant failed in his claim for direct discrimination, the legislation breaches his Article 9 rights, we say you can't get
Keep going,
we still cannot use Section 3 to do what the parties invite the court to do. We say that is because of the well-known limitations on the operation.
All right, I understand that, but what are the actual points?
The actual points are you can't change the substance of a provision from saying one thing to mean the other. Okay. And you can't adopt a meaning inconsistent with the fundamental feature of the legislation.
Yeah, well, that's really what it's about.
Yes, that is what this case is about. And, my Lord, what I do have to emphasise is that Section 3 is a question of statutory interpretation.
Well, up to a point. I mean, technically it is, but we all know. But
my Lord, it's a very far-reaching. But
I mean, frankly, on this point, unless there's some particular point you want to make, we're all very familiar with how Section 3 works. We're familiar with the problems both ways, and it always comes back to Guidon in the end.
Absolutely, but my point is, no one has put forward an articulation of what the statute should look like post the Section 3 interpretation, so that one can assess, is this cutting across the fundamental feature of the legislation? Is it inconsistent with fundamental features? Because parties applying this, tribunals applying this, have to know what the statute is supposed to look like post Section 3.
Well, up to a point. Again, there's actually dicta which say you don't have to articulate what the how you would amend the statute to achieve
Yes.
compatibility.
But my lord, one has to have an idea of how it's going to work in order to assess
Yeah,
whether
well, I
it
do see the
breaches
general
those fundamental principles. My lord, I'm
One
conscious of
point
the
on
time.
which, before you sit down, I would welcome assistance from you if you had a chance to do it over the short adjournment, was what are the public law authorities on the role of an appellate court in conducting a bank merit assessment? You I think mentioned a case briefly. Did you say Dawson?
Yes, my lord, it is. I'm just trying to find it as I sent a copy.
It's
to my
only
own
because you were
friend.
volunteered by Mr. Jones as the person in court who knew more about public law
Yes,
than anyone else.
my lord, it's Dalston Project.
Dalston Project.
It's 2024. 1 Weekly Law Reports 3327.
And that's a decision of this court or of the Supreme Court?
It's of this court. It's a judgment of Lord Justice Singh.
Oh, I think I know the one,
Yes. And my lord, that looked at all the conflicting authorities. Is proportionality a finding of fact? Is it a question of
Okay,
law?
so we can go and look at that. Or Mr. Mr. Adair was waving it at us, but maybe he wasn't. We can if we need guidance on that point.
Yes.
We can. That's the last word.
That's the last word. That I
Okay,
think
that's
it's-
very helpful.
It's
Thank
from
you.
very early this year, so I'm
Right.
not aware.
Now that wasn't what you were standing up to deal with.
But I'm happy
I
to
think
assist.
we are running out of time. Is there anything else you feel you need to say that isn't in one or other of your sets of submissions?
My lord, the only point, the very important point from the Commission's perspective is not to overlook the concerns about stereotyping and third-party complaints. The
We won't.
submissions
I
are
promise
there-
you, we won't overlook them.
Yes, and the submissions are there in writing. I'm not going to take up the court's time by repeating them, but we say that is a way through, also a different way through some of these difficulties that the gauge is working with.
Thank you very much. I'm sorry you lost 5 minutes of the time you were expecting, but you haven't done badly. You haven't done badly for time. Or in any other way.
We're just exchanging
Sorry.
kit.
Yes.
Sorry.
Well, Mr. Adair, you've got considerably longer than one would normally have for
Yes,
a
indeed.
reply. I don't feel obliged to use it, but it's there if you need it.
I shall not be obliged to use it, my lord. My approach will be to seek to deal with any new matters that may have emerged from the submissions thus far, but also to remind you of some key points which I fear may have been lost in the welter of legal learning.
The first is absolutely what replies are for. The second is all right up to a point.
I shall be quick and
Reminding us of points that have genuinely got lost is fine. Merely repetition is not. Okay, off you go.
Lord, I want to begin by correcting myself on 2 matters of fact that arose in the course of my submissions. One was the question, far too technical for me, of how Facebook posts can find their way to third parties. I've done, or had done, some research overnight from those who are truly technical, and they tell me that the answer is that it can only be done if privacy settings have been set by taking a screenshot. So the tribunal was right.
I see, right.
Secondly, on...
Hang on 1 second. But you would no doubt say that is not all that difficult to do. It's perhaps not quite as easy as simply clicking forward to all my friends, but it is not difficult. Right, okay?
Anyway, so my second point is this. There was some submissions from Mr. Jones about who it was that Miss Higgs was talking about, which concluded with a submission that in effect she was undermining what was being done in her own school. in fact, if you look at the posts, it is clear that she identifies her concern as being primary schools.
Is that right? I mean, it's true. I thought it was two things. I thought it was a government policy for primary schools, but also for secondary schools.
Well,
I think it may be a fairer comment, as I looked at this, is that it's criticising the policy that schools are being required to implement.
that's certainly so. In any case, because
Shall we just get to the bottom of this? I respectfully agree with my lady. That's very much the thrust of it. But let's just see. It is both. I thought it was both primary and secondary. 149 in the core bundle. November 7th, government consultation into making relationships education mandatory in primary schools and relationships and sex education mandatory in secondary schools.
Right. I may be wrong in that respect. The other place at which I was looking at it was 158.
That which is her text, as I understand it, is Mrs. Higgs' own text.
Yes.
Yes.
Yes, thank you. Yeah, I see. So perhaps the right way to analyse it is to say that by endorsing or by cutting and pasting the general text, which she didn't actually write, that's a general attack on government policy affecting both kinds of schools, but she herself has added a comment about her local primary school.
Yes, on page 150 at the bottom of the page, it says, this is happening in our primary schools now.
The way these have been reproduced is very difficult to follow.
That was clearly her comment.
I'm sure it is, but but that's a different post, is it, from...
I think it appears more clearly in the EAT decision.
Does the EAT correctly sets out all the relevant ones, in which case we'll look at those? To be fair, we were referred to those, but I'd got used to looking at the original texts. So if we compare that with the actual documents we have in the bundle, paragraph 5 corresponds exactly to 149. And then you have to go on to 158 to see how the line continues. Is that right?
Yeah. Yes, I think that's right.
And EAT paragraph 8 reproduces
The Beth. Judy Beth.
But
What's 150? The very bottom of 150. Is that a different post?
Yes, it's a different. I wonder if that isn't reproduced in the EAT, but it looks like it introduces the American text.
Yes, I see. Yes, again, my lady has looked at it more intelligently than me. That's obviously right, but it's not reproduced. Okay, thank you. Right, not worth spending more time on that detail, but thank you.
So, I want to, having made those words introduction and correction, to just make clear, and I hope justifiably remind, of the scope of this appeal. Can I take you to page, the decision in page, bundle 7, the authorities at page 442 and page 68.
Sorry, 442 did you say?
Page 4, bundle 7, page 442, paragraph 68.
68, sorry, I thought you said 58. Yep, we've got it, yes.
Of your judgment.
Yep.
Unless you want to, given the time, I won't ask you to read through that passage again because it's been read already. But it is very important, and it's important for this reason, that in my submission, that passage states that there is an objective question to be considered, which is set out under the numeral 2 in the middle of the page. And that is made clear throughout the paragraph, and in my submission it can't seriously be argued without doing violence to the text that whether or not my Lord wishes now it had been done differently, an objective test is required. And that, under the doctrine of stare decisis, cannot be withdrawn from today, because this court is bound by its own decisions. And that is not, in my submission, a formal or overly formal or empty matter. It is only right and proper in constitutional terms that if a party is dissatisfied with a previous decision of this court, then unless it is properly distinguishable, which we say it isn't, the only place in which it can be overruled and reformulated is in another place.
Well, that's obviously right. But it remains to be seen, not so much whether we distinguish, but whether everything said here is ratio.
Oh, of course, I agree with that, but I'm simply putting forward my submission as to where the ratio is found on the plain reading of the text. The second point, however, is even more pragmatic, and it is this: whether or not one takes the view that page does have the ratio as I have suggested, nevertheless, what has to be decided in this case is what the EAT thought it was in its judgment. In particular, that the ET ought to consider whether the interference of the school in this case, the claimant speech, was a proportionate means of achieving a legitimate aim. In principle, it was open to the respondent to cross appeal and state that Mrs. Justice Eady was wrong, and or that, well, depending on the status of page, certainly that Mrs. Justice Eady was wrong. The respondents applied to do that not once but twice, and it was refused. And those decisions of my Lady Justice Lang cannot now be sidestepped, however clever the arguments. Again, it's a question, constitutional law puts it too high, but of the proper procedure in the civil courts. The way you challenge a judgment as a respondent is to cross appeal. And if you fail, or if you don't get permission, that is the end of the matter.
Yes, well, that must again be right. But again, we may need to distinguish between what the EAT ordered,
yep,
which can't be challenged,
yes,
and some things that it may have said which, if we are persuaded that they need correction or amplification or whatever, it would be appropriate for us to do in our judgment.
Well, save this, that in my view, the ratio of a case includes not only the order that was made at the end of it, but also the legal reasoning on which it was based.
Well, I wonder if that is actually technically correct. That is obviously true about what the ratio is, but in terms of what you can challenge without a cross appeal, I suppose what you would say is it's the other kind of cross appeal, where you're not challenging the order, but you're saying it should be upheld on different reasons. But that's not a cross appeal. That's something that you do by way of respondent's notice, so that everyone knows what's going to be argued about.
Indeed.
But if that is done, or even if it isn't done, there's no prejudice by the failure, then I don't think the mere fact that the order can't be challenged necessarily means that we can't have things to say about the reason.
Well, save this, that the classical respondent's notice says we object to the reasoning of the court, but we uphold its decision on different grounds.
No. It can do one of two things. It can cross appeal, which means there are parts of the order that we wish to challenge. So we have our own appeal, but because you got in first, it's a cross appeal. That they have not been allowed to do.
Right.
But a respondent's notice can also do something quite different, which is to say we don't want to challenge any part of the order, or even if we do, we haven't been allowed to, but we don't like some bits of the reasoning, or we think there's better or different reasoning on which it ought to be upheld. And that isn't how it's been done now, so there's a procedural defect, but there isn't a jurisdictional defect in our making observations about the EAT's reasoning if we choose. It may not choose.
Well, can I put it this way? The EAT has, as it were, set the agenda for the ET, to set it that it must consider whether proportionality, etc. I've mentioned that several times. If it has set that agenda, then that agenda can't be altered in my submission through a respondent's notice.
Okay.
Mr.
Well,
Goodyear, if I can just express a view on this, it's very often easier to look at the practical objection rather than debating the point in abstract constitutional terms. Speaking for myself, I think that there would be great difficulty in Mr. James or anybody else on the other side trying to re-argue the terms of the paragraph 1 of Mrs. Justice Eady's order that has set a question paper for the tribunal on remittal. You're seeking by your appeal to say remittal isn't needed at all, but as to if we're against you on that, so to speak, and there is to be remittal, then it's quite difficult to say that every single syllable of the judgment to Mr. Justice Eady has to be treated as Holy Writ, but it might be useful if you're saying there's something in it that's actually wrong, if you tell us what is actually wrong, and then we can consider it.
Well, no, I don't take that view. I take the view that the judgment of Mrs. Justice Eady on this aspect of the case is right. And that
you're happy with every word of paragraph 94.
Well, may I just quickly go to paragraph 94? Make sure I'm not.
But to be fair, your point is more that it's not your point, whether it's right or not, it's not a matter, but your point is that it's not open to Mr. Jones or any of the interveners to say to ask us to qualify para 94 in any way.
Paragraph 94 is the guidance. Is that
Yes.
No, that's right, but I do say that. But in addition, the matter, the point that I refer to is paragraph 96, first 3 lines. The claimant's appeal is allowed and this matter is to be remitted for the determination of the question, and the question is set out. Seems to me.
Yeah,
that
but, all right, but I don't know why you're looking at that. It's the order. I assume that's in the same terms as the order, but it's the order which we go by, which is at page 41.
Yes.
I haven't looked word for word, but I think it is in the same terms as what I expect.
Yes.
But just formally, it's the order, not the judgment.
Yes.
Yeah. Okay.
So.
Right, well, I think we've explored that as far as we
Yes,
can.
indeed. I'm just going to move on now.
Yeah.
Other matters. Now, I want to address now what might reasonably be said to be the fundamental question in this case, subject to the discussion we just had, which is whether this court can say that there can only be one result to the question of whether respondent's interference was a proportionate means of achieving legitimate aim. The proportionality question, as it's been described. Mr. Jones, King's Counsel, relied on the outcome of Page for the view that sometimes the reasonable apprehensions of third parties are sufficient to justify interference. And he suggested that this case was a similar one, given what was found in paragraphs 61 and 62, 63 of the ET judgment. It's important, though, to take note and to remind oneself of a point my Lord Justice Underhill said in discussing Page in these proceedings, that there was that effectively the potential harm to third party hearers, was effectively conceded by the appellant in Page. And that's found on paragraphs 53A to B and 55 on 438 and 439 of the judgment. And my Lord noted in passing that there might have been, but for these concessions, an example, a question about whether the evidence justified the apprehension. And in my submission, given that, this case is very different, and a finding for the respondent could not be justified by means of the analogy with Page, alleged analogy with Page, and for this reason that we say that in this case, the principal source of evidence in this case against the claimant was a discriminatory stereotype. A person of these views would probably be a danger to LGBT children. So not only do we say there is no evidence, but we say further that there was, in effect, evidence to the contrary. And it's right to say, in passing, that the question of the extent to which evidence is required in order to establish, let's put it this way, derogations from Article 9 or Article 10 is a very important one. If it's made too easy for those who seek, sorry, look.
No, I'm just, I can multitask. Your last words were, if it's made too easy.
If it's made too easy for those who want to interfere with freedom of speech, if it's easy to say, oh, well, we're afraid that so-and-so might be extraordinarily distressed, or so on and so forth, then freedom of speech is in peril. It's a very easy argument to make if no evidence is required to support it. So, I want to come on now to the language of the posts and to the suggestion that action was justified because of language such as the reference to brainwashing and all that sort of thing. So, excuse me a moment, I'm just going to take you to Martin and Devonshire in Bundle 5 of the authorities. At page 84. And paragraph 22, which in fact is page 96 of Bundle 5. This is my Lord's discussion at a relatively early stage of the development of the law in this area of the possibilities for separability. And between letters C and D, my Lord begins at B and C by introducing the concept, and between C and D it said this: the most straightforward example of separability is where the reason relied on is the manner of the complaint. Take the case of an employee who thinks in good faith a complaint of discrimination, makes in good faith a complaint of discrimination, but couches it in terms of violent racial abuse of the manager. And my Lord used that example yesterday. And the answer that arises in the following text is that in such a case there would be a separability argument. And one should note, however, that is, of course, and this is the way argument works, an extreme example. Very clear example, nobody could hope to argue with it. But let's go down now to the text between letters F and H. And I would just ask you to glance through that text, if you would not mind.
Sorry, Australia, which paragraph?
It's paragraph 22 on page 96 of Bundle 5.
Yes, thank you.
Paragraph 22 and letters F to H. So, my Lord reminds us there that it would certainly be contrary to the policy of the anti-victimisation provisions if employers were able to take steps against employees simply because in making a complaint they had, say, used intemperate language or made inaccurate statements. An employer who purports to object to ordinary unreasonable behaviour of that kind, contrast the example above, should be treated as objecting to the complaint itself. Now, in my submission, stepping out from the technicalities of separability and causation, and so on and so forth. My Lord has absolutely right there where the law should get to. And my Lord's never been said to be wrong in that either. And in this case, that is very important because the substance of the discussion there, of course, feeds into the proportionality argument, which the EAT has bid us undertake. So, and further, the weighing of the interests that one sees in that paragraph is that which is found in the decision of the ECHR in De Hailson, Belgium, which is referenced in my skeleton argument. And more locally, it's been effectively adopted by Mr. Justice Miller, Mr. Justice Knowles, in the case of...
These are all points you made in opening.
Okay, I'll move on then if it's... But what I will do then is come directly to something I hadn't addressed, which is this, which is the reliance by my learned friend on the case of Yinielski.
Yes.
And the phrase gratuitous offence.
Yes, that would certainly be helpful. Thank you.
Now, the phrase...
Remind me where the case was to be found.
It's, I think, to be found in volume 4, Tampa.
Yes, it is. It is right. Impressive. Yeah, thank you.
I'm afraid I've lost the paragraph.
Well, it doesn't matter. We can find that. But paragraph was 43 on page 177.
Thank you. I'm very grateful. There is reference in that text to the effect that gratuitous offence is not protected, and there arises, as a result of that, inevitably, a question of law for your lordships, which is, what does that mean? What does gratuitous offence mean? It's not defined in that judgment, and as far as I know, there has not been any systematic attempt to define gratuitous offence. But in my submission, what in a convention context it must mean is abusing free speech rights so as to exercise a desire to offend. It must be interpreted narrowly, because if it's interpreted very broadly, it will end up being something close to speech which causes offence.
Yeah.
Which we know can't be sufficient. Of course, as my Lord Justice Bean has said more than once in this hearing, one has to look at things in context. And the context in this case is of Mrs. Higgs being clearly passionately concerned as a mother, as a parent, and as a committed Christian about events which she saw as being harmful to children. And, of course, one has to remember to start with that some of the language was actually somebody else's. And unless she'd stopped and edited, she couldn't avoid that problem. But even leaving that point aside, it's my submission that it couldn't possibly be said that the language of this text was in context gratuitously offensive. It was part of a passionate debate about a matter of very significant public interest. And it's important to note that to some extent the concerns, leaving aside the language, which she had, have come to be shared by a much wider audience, Cass report, and so on and so forth. Her views are, on any view, not, in my submission, off the scale. I want to come now to address the reference to Lilienthal, which...
The reference to... Oh, Lilienthal, yes. Yep. Again, remind me where that is.
That is...
It's in volume 7, page 364.
Thank you very much. Volume 7, page 364.
Volume 7, 364. That's all. Yeah, 7364.
Yep. Yes.
Yes, I'm just looking through that. Now, the obvious point to make in this case emerges, or about this case, emerges from paragraph 5, where the language with due allowance for for Icelandic translation is set out, and it is clearly extraordinarily virulent. It's fair to say that Mr. Jones made an accurate point, which is that there is a boundary to the tolerance of freedom of speech, which this case illustrates in this respect. However, one imagines the boundary as a circle. In my submission, it's clear that the language of this case put the complainant in this case well outside the bound of protection.
I don't think Mr. Jones was relying on any of these cases as comparable on the facts. He was looking at them for the statements of principle.
Well, of course that's right, but I would simply say this, that agree and say, well, those cases were just extraordinarily different.
Yes.
And particularly when one is looking at the case of a person whose speech occurred in the course of a political debate, an online political debate. But it is important to note that there was some suggestion in Mr. Jones's oral submissions that his oral submissions that the claimant's speech was offensive because it was directed in an unpleasant way at the LGBT group. And so, with that in mind, it's important that I draw your attention and remind you of a submission that I made, which is that this is not a case in which the posts were involved in animus against the LGBT community. It was a case in which the claimant was objecting to people of whatever sexual orientation who held particular views on education. In other words,
Well, that may be a little bit bland. Isn't there a reference in the reposted post to the LGBT community or the?
yes, there is. There's certainly a reference to it, but the question is why? And it's the objection throughout that post is to people of whatever orientation who are taking a particular view on education. So moving on from there, I want to come to, within that same overall thread, to reputation, which Mr. Jones advanced as a reason why you might not be able to remit. Sorry, why you should remit and might not be able to decide the case.
Yes.
As to that, I would simply say this, that the key fact in the case is the finding in the letter of the school, the letter of dismissal, which acknowledged that nobody would assume that the school's views were her views. And that being so, we say, any damage to reputation was so slim and ill-evidenced that it did not and could not justify an interference with political speech of this kind. I want to come now to ground 3, which is about third parties and stereotyping. And to draw to your attention what the appellant says about the Amoeba case. The Amoeba case, taking out irrelevant side issues, was about a lady who was awarded a particular role in a stage play called The Colour Purple, which required her to portray someone who was a lesbian. It was later found through the investigation of her media, social media, that she had very conservative Christian views on marriage. As a result of that, there was a media storm, at least in the world of theatre productions, and a demand by third parties that she be dismissed. And she was. And it was held by the ET and affirmed by the ET that this treatment was not by reason of her beliefs, but by reason of the media storm. In my submission, that...
Well, not just that, the media storm which might lead to financially catastrophic consequences for the theatre.
Yeah, absolutely, absolutely. But what that raises is an issue which is relevant to this case, which is, are you entitled to justify what would otherwise be discrimination by reference to the reactions of third parties? And we know from the case of Roma that the answer is no. And so, whilst it might be thought at first sight that the Amoeba case is contrary to my proposition about third parties and so on, with respect, all that it does is to raise questions about its own consistency with what Lady Hale had to say in Roma. And so we say that one of the reasons why the claimant was subjected to detriment was that the third party, the parent, objected to her views and subjected her to a stereotype about her behaviour and how she would mistreat children. If that is right, and we say it is right, then in a sense, one can then it follows that the appellant is entitled to succeed in this court, even if it fails on the proportionality issue. And that is because the adoption of the objections of the third party was itself an act of discrimination, which could not be justified because it is an act of discrimination. It might be said, and I think it was said in argument, well, no, that was that concern with potential harm to the children was not something that came from the third party. It was what the school said itself. That's the way it was put, I think. But in my submission, that can't help the school, because if it bats off the claim that it was adopting the reasons of the parent by saying that those reasons were its own reasons, it ends up being liable anyway.
Well, these are all points you made again in opening. I don't detect that they reply to any particular point made by Mr. Jones.
Well, I think it was the point that the school had these reasons for of it in and of themselves rather than through the third party. I think that was the point I was aiming at.
I see.
So, being aware of the fact that I have to finish by 4:15, and having addressed you on the way in which the agenda set by the Court of Appeal, EAT, should be fulfilled, I just want to come to the broader questions about which so much time has been.
Yes, thank you. That would be helpful. Just before you do, I forget whether I asked, but if so, I've forgotten the answer. Do we know whether Omuba is the subject of any appeal to this court?
Yes.
As I understand it, with a malicious irony,
Someone in this room refused permission. Yes, right.
I mean, I don't know, but it may be that there's some consideration of taking the case to Europe, but that doesn't affect your direct.
Very well. No, thank you. I was just need to be careful what was said about it. Yep. Okay.
I just to follow on that briefly. I mean, my understanding is that reasons for the refusal of permission cannot be relied upon, and that is why I haven't taken steps to obtain copies of those reasons.
No, well, you're entirely right. You're entirely right. No, I was only asking simply because if we have to say anything about Omuba, we would have to be particularly careful if it was the subject of a pending appeal.
Yes, I understand that. So the conceptual scheme. The ECHR, Ms. Clement said on behalf of the ECHR in her submissions, said that Section 10 includes manifestations of belief, and she rightly says that stems from Uganawi. She also says that there are no limits on those manifestations to be imported from the ECHR. And indeed, as I understood it, she did not suggest there were any other source which might distinguish some limitations, some manifestations from others. In my submissions, it's important to observe that the protected characteristics are not all of the same kind. Most famously, it's been said, and rightly, that age is different because it's not binary, and because all people go through different ages, different points in their life. But it's rightly said that other protected characteristics like gender and race are very hard-edged. It's not difficult to discern the meaning of race, although gender maybe is more problematic in this day and
Whether
age.
the act is sex, isn't it?
Yes, I beg your pardon. Apologies. But those protected characteristics are hard-edged, relatively easy to define and apply, and they are subject only to very specific exceptions, such as genuine occupational qualification and so on.
All this is interesting, but where's it going?
Well, it's going this. I'm going here. That the various of the interveners, particularly the respondents, have sought to portray the protected characteristics and the conceptual scheme of the Equality Act as running along very tight lines. So it said that, well, all cases of direct discrimination are subject to a requirement that the action must be by reason of the protected characteristic. And that in contradistinction to direct discrimination, there is indirect discrimination. And there are those two modes of proceeding by which policymakers have proceeded. Now, in fact, that's not quite true for this reason, that the binary distinction between direct and indirect distinction is not followed through in a doctrinally rigid fashion. For example, section 16 of the Act, discrimination arising from, has a different conceptual structure. Similarly, section 18, which deals with women who are penalised as a result of something arising from pregnancy, particularly illness, in the case of Brown, again, deviates from that simple conceptual structure. In addition, there are cases such as James and Eastleigh, which again don't follow that simple structure, because there's a category of cases where conduct is said to be inherently discriminatory. Now, bearing those things in mind, I want to address what is said of indirect discrimination in this case. It is said that the legal problems raised by manifestation of belief should be addressed through the mechanism of indirect discrimination. In my submission, that is true to a point, but potentially misleading in this respect. That if there is a choice between a direct and indirect discrimination case, the significance of the respondent proving a PCP is that it effectively defeats the direct discrimination case by showing that.
Sorry, you mean indirect?
If it's said that the respondent have acted in application of a universal rule, the effect of that is, depending on whether facts are made out, that's the plea, the effect of that is that the claimant can't succeed on direct discrimination because the reason why he was mistreated was the application of the rule.
Yes.
But may be able to succeed on an indirect discrimination.
Right.
Now, the problem with the way it's been put forward to you is this, is that it's not indirect discrimination or nothing. And what I mean by that is this. If we have a case where there is no PCP, for whatever reason, evidential reason, was not pleaded or whatever, then there is no reason why the claimant can't seek to prove direct discrimination. So, so the simple answer to the discussion is this. It may be that a claim for direct discrimination is defeated because the respondent proves a PCP, or even the claimant does choose to ride that horse. It may be that so. But if they don't, the mere theoretical availability of the claim does not prevent the direct discrimination claim. And the other thing to say, or one other thing to say, is this, that the law on indirect discrimination is not fit for purpose. It's not fit for the purpose of ensuring the protection of Article 9 and 10 rights. There are a number of reasons for that, but the most obvious one is the issue of group disadvantage. The claimant, or a claimant, may have a good case for Section 9, breach of Section Article 9 rights, but won't be able to bring that through the indirect discrimination mechanism unless he or she can show group disadvantage, which may not be possible. And the case that illustrates that in particular is the case of Umbar against the Mayor and Burgesses of the London Borough of Merton, Authorities A6, paragraph 12. In my submission, it's worth. No, sorry, I'll start again. I want also to add this. Suppose that a claimant brings a direct discrimination case on the grounds of manifestation of belief, but the manifestation, and it's argued that the treatment was by reason of the manifestation. And suppose that is found to be the case, as in the case that my Lord identified in Devonshire. Should it necessarily be the case that the employer, the respondent, loses? It's a manifestation of belief. It's the the over-the-top expression to the manager, but it is by reason of that manifestation. What is the employer's way out? If you adopt the framework put forward by Ms. Fraser-Butlin and the Free Speech Union, the answer is this. The way out is that this particular manifestation is not protected under Section 10 because it is accepted, sorry, it is withdrawn from protection by Article 10.2. The point that I'm making here is simply this, that it's been said a number of times that the analysis proposed by myself, Mr. Fraser-Butlin and Mr. Cooper is unfair to respondents. But in my submission, that's not necessarily so, because the alternative analysis put forward by Ms. Clement leads to a situation where there is no juridical basis for excluding the extreme manifestation of the kind seen in Devonshire. Now, of course, one way of doing that is to fall back on a separability argument, which is to say, well, okay, yes, the respondent escaped here because the true reason, as a matter of factual causation, was that the detriment was imposed not by reason of the manifestation, but by reason of the extreme behaviour towards the manager. Now, the problem with that is that it doesn't tackle the real issue. As I think Ms. Fraser-Butlin said, the real issue in the question of what limitations should there be is a value analysis based on the legal values emerging from the case law in this field, and in particular from the Human Rights Act. The plea that's being made by Fraser-Butlin and Mr. Cooper and myself is this, that what is needed is a transparent working out of what limitations there are on protection of manifestation of belief. Because unlike, and that's needed because unlike race and sex, no one seriously thinks that the answer to the question which manifestations are protected is all of them. It just can't be right. That is why the end point of the analysis is that I support the submissions and solution put forward by Fraser-Butlin and Mr. Cooper. Although, and here I do draw to a close as I'm required to, because it's nearly 4:15, I want to end with this, that interesting though these submissions are, they are not the issue before you. My Lord, thank you. That is my reply.
Thank you very much indeed. Well, no one will be surprised to know that we'll be reserving our decision.
Well, Lord, before you do, you
Yes.
spoke yesterday about the possibility of allowing us a few minutes to respond to intervener submissions. You may have
I
changed
did,
your mind.
you're quite right, and I'm sorry, but I think it would have been better, well, it doesn't matter. I'd rather assume that would be done before Mr. O'Dare, but do you need it?
I think I do, but I can keep it to under 10 minutes.
Keep it to 5 minutes and you're fine.
5 minutes is under 10 minutes, so I'll get there. There we go. Can I do it then by way of essentially bullet points.
Yes.
My learned friend, Mrs. Fraser Butlin, I think makes our case very eloquently with her 1% point. So she says, well, in 99% of the cases, it's likely that direct discrimination is going to help you, but in just 1% of those cases, there may be a case in which, when you look at the facts, there's no discrimination. Then what do we do? How do we provide a protection for a breach of a convention right? Well, the short answer is, if you've looked at the facts, as she says, and there's no discrimination, then the discrimination provisions, anti-discrimination provisions, shouldn't be helping you. And in response, you'll recall, my lord, you said, well, they'd have a cast iron unfair dismissal case, and that was agreed with. But that's the answer, isn't it? 99% of the cases, you may bring home a discrimination claim. In the 1% you can't, you're almost certain to succeed in an unfair dismissal claim.
But if it's a dismissal case, it might be a detriment other than dismissal.
It may be, and there are other protections for various other forms of detriment. So it just isn't clear to me that, in the light of the admission that in the absence of discrimination, something must be done, anything is being said other than you have to hammer in what is in effect a freestanding protection for a breach of convention rights into the Act. And we know from Mbar that we're not in that business. That's not what the Act is intended to do. And it's not what the court should be looking to do, to be creating a freestanding protection and then finding somewhere in the Act to slip it in. The next point is the discussion that my learned friend Mrs. Fraser Butlin had with her ladyship about views and about indirect discrimination. Can I just insert this note of caution in relation to views?
In relation to what, sorry?
In relation to what views are. So this case is a case about specific protected beliefs, not about the expression of views generally. We have, in the course of making submissions, drawn a distinction between the protected beliefs themselves and the manner in which they are manifested. And we've tended to talk about language. But it is worth bearing in mind that if you look at the post, there are a lot of views in that post, or things which could be categorised as a view. So if you say,
I haven't quite understood what you mean by a view.
well,
What's that? You using it in some special sense, or?
no, what I'm saying is that it's being used as part of the analysis. It was the terms in which the discussion took place. But precisely your point, which is that it isn't defined, and it will cover things
What
like
isn't defined? The word view.
the word view. It will cover things.
Why is
like,
the word view coming in? Why are we talking about it at all? Have I missed something? Does it appear in? What do you respond? Did Ms. Fraser Butlin talk about views?
Yes.
Oh, I see. Well, so I just assumed she was talking about protected beliefs, but I didn't even pick her up on that.
Oh, good.
word.
If that's the position, if that's the way in which the court has understood it, then I'm wasting your time saying anything more on it, and I won't. So as long as that we're understood that when talking about views, it's just the protected beliefs that
Very well.
and the particular protected beliefs that matter. So the ones that are relied on specifically. Then moving to the point about our having drifted a long way away from what was described as the subjective but-for test. The but-for test is not a subjective test, it's an objective test. And in the James and Eastleigh approach that was described by Mr. O'Dea, you might use a but-for approach, but we know endless authorities, including Nagarajan and most recently Amuba, that subjective test does focus on what's happening in the head of the employer, or in the decision maker, I should say. It doesn't matter that might take into account subconscious factors. So the tribunal has never, at least in the 30 years I've been doing it, considered themselves to be bound by what an employer or a decision maker says their reason was. It's open to the tribunal, if it wishes to delve into the subconscious and say, you may think this is what your reason is, but we conclude it isn't.
Yeah.
But that process is still looking for the actual subjective reason. So then, 2 points in conclusion rising from what Mr. O'Dea has had to say about the...
Oh, hang on, no, you've got no reply to Mr. O'Dea.
Then I'll sit down. Thank you.
Very well. Thank you very much. We will, in the usual way, circulate draft judgments in advance of formal hand-down for the very limited purposes identified in the Counsel General for Wales case, which I needn't remind you of. And especially as in this case there will be a number of people who will get the benefit of this, including the interveners, both those present and not, it's particularly important that I emphasise that they are being circulated only for that purpose and should only be shown to someone to whom they need to be shown for those purposes. And if there is any circulation of the draft judgments except in accordance with those principles, there is the risk of contempt of court. So please do be aware of that. Very well, I only managed to say how grateful we are for the submissions of counsel and for the submissions we've also received in writing, and for the work not only of counsel themselves but those behind them, which have clearly fed into those submissions. Thank you.
But obviously it was handed up after given
We won't
They're
let
not.
you.
I don't think they to, but sure that
Yeah, it was
somehow we are told.
Yeah. I don't know they're interested.
I don't think they're interested, but I would hate the opposite. I would hate it.